It is time to start, so let's go ahead and start.
Hello, everybody. We will start as it is 1 p.m. I'll be moderating today, and today we have a presentation by Norravich Limpanukorn. I hope I got it at least a bit right on U.S. copyright law and AI, the perspective of past, present, and future. Norravich is pursuing currently an LLM in commercial and corporate law at QML. Queen Mary University. He has his LB in business law from Massachusetts University and LM in IP law from IU. He worked professionally in Baker McKenzie and in the IP Tech and Dispute Resolution Practice Group. He also contributed to research on the EU AI Act, which is also a theme for today. Today's presentation will be about exploring the US copyright law, especially focusing on the some interesting cases that happened or that can happen regarding the copyright and AI. The aim of the presentation is not to introduce like a new theoretical framework or like a new way of completely new way of looking at it, just to analyze the cases that actually happen in this AI and copyright framework. Now, Karen will pass.
Yep.
I will start the presentation.
All right, thank you so much for a very kind introduction. A little bit remark. I'm not working at Baker McKenzie anymore. I just used to be trainee that right before I joined Marvel School of Law. So anyway, thank you so much for like an introduction, very accurate. And I don't think that we have to talk about the agenda today, but just a little bit of idea that what we are going to speak of today will have to deal with like these certain topics. Um because the moderator already introduced me, so I don't have to talk about this anymore. So what am I doing? Because this technically is just part from what my project under mentorship of Professor Scott uh, is currently running. So I just try to compile case book. The motivation is just like there used to be a time I was in Professor Kate's class on law and technology, artificial intelligence. It's a very good class. I very encourage everyone to join it. But I just wonder, like, what if instead of like we try to collect those of things from journal articles, reports, and newspaper, actually have like a books containing of the cases that will be useful for this area of law. It will be very interesting. So I'm trying to do it. I'm trying to address various area of law, but obviously if I cannot finish it, I will just descale the book anyway. So um, pretty much of introduction. So we are doing a deep dive today in a fast-moving areas, the U.S. copyright law meets with artificial intelligence. And for those who do not have basic or those who want to revise, um, the protection of copyright is just exists for the original works of authorship fixed in any tangible medium of expression, and that is Section 1028 of the Copyright Act. So those specific words, original, authorship, and fixed, that is pretty much of every legal fight over copyright dispute nowadays. So we technically have got four main areas to tackle today. So the first one is about originality. Second one is about who gets to be called an author. The third one is tricky questions of style that I would like to add on a little bit. And lastly is the huge one is training data and fair use. And we have like a recent decisions on these. So let's jump into originality. I'm sorry. So fights, the standard is very pretty low. It's just like a minimum spark of creativity, or what we know as like a modicum of creativity. Plus, you have to make it yourself independently, and even for derivative works, things based on something else, the previous work. If I isn't really higher, so we can see like a standard of originality in shock. Let's say the originality here is no more demanding, at all. So I would like to start by mentioning these review board decision. Um, it is not the first well-known board decision as an AI-relevant method is Survey of the Dawn, but the image here generated by Midjourney and then the human, Mr. Allen, made the adjustment using Photoshop and finally enlarged it using gigapixel AI, as you can see here in the red color. Uh, so I put the CF here a little bit, so in case anyone want to look further on maybe comparable case, I think this one Alfred Belko is comparable. But the point that I want to raise here is like the board basically said they didn't have enough information to decide if Alan's Photoshop alone were creative enough for copyright. So these leave some room for copyrightability as long as the edit that made on top of AI generated work had sufficient creativity. And that is correct. But the really revealing part was the conception about the gigapixel AI enlargement. So just making it bigger didn't count as authorship because it didn't add anything new or original. It was just a mechanical step. So that leads to what I think it is a kind of conceptual puzzle. So if the adjustments were all done on his own in the absence of gigapixel AI, so like the work here, the right side, uh, was done alone without using AI, do you think um this work will be copyrightable? Um, do not have the answer, but my answer would based on the provided decision in short in this part that whether or not that is sufficient non-trivial expression variation in the derivative work to make it distinguishable from the underlying work in some meaningful way. So that's why I asked you guys to compare with Alfred Belko. Um, that is something that maybe I want to read from this one, not think much. Um, and another questions. So in this one, the question is that if the AI generated image itself is seen as lacking human authorship, meaning it's not an original work to begin with. So can a version modified by a human even be a derivative work under the law? Um, so you need an underlying work to derive from, whether it is copyrighted or ended in public domain. But does that work needs to be a product of human authorship from the beginning? Um, that's really tricky point. I think the report here in the report of copyright and artificial intelligence part two that I provide may be a little bit too broad. So even if the previous work is AI generated for me, um, I think the derivative work would constitute it. So we move a bit further to a well-known case, is Survey of the Dawn. Um, I think this case is about purely AI generated images that is not copyrightable, but it's about the human author's work in selection and arrangement, the image that is copyrightable. It sounds like a clear lie, but then I would like you to look in the details on something that was not really raised up when we are talking about this case. So we can see like the picture in the left is a picture before edited by Photoshop, and the picture in the right is the picture after the edit. Um, the copyright office point out that the change is very minor, so there's no protection over the change. Um, well, it's do not really difference, but I think it's somewhat outer. So first question is that Syria is not work of authorship. So if the chain is perceptible, will the owner get the registration since the office mentioned like the pre-existing work must come within general subject matter of copyright set forth in section 102 in previous like regardless of whether it is or was ever copyrighted. So does this cover requirement of human authorship? Uh as I mentioned, my answer would say yes, you can copyright it. Um, But another thing is that I would like you, if you study copyright law before or general IP law before, you know this case is the fake statute of like a statute of liberty. So there's like a slight change on the statute that is like making it face a little bit softer, more feminine, jawline less massive, whatever the court have mentioned. But if you look at the actual picture, it's not that much difference. It's not that much difference. So even the postal service confused. So if applying the Davidson case to like the image of Survey of the Dawn, should it be agreed with the copyright office that they change to Syria mouth, lips are too minor, something like that. So so real question is that if it could be established that the authors made Cyrus' face more feminine, more rounded, have lighter skin, something like that, will it satisfy the board? I doubt that, or maybe copyright office will just set higher standard if the previous work uh is AI generated, and I feel like it is. So it feels like when AI is involved at the starting point, the copyright office is looking at the human contribution much more. They seem to want a really clear, noticeable break from what the machine produced, and that seemed to be a trend. High bar for human input. So the key is unaltered human picture authorship that is clearly perceptible in the deposit and separate from the non-human expression. That thing is registrable. And then this lead to the questions, a lot of questions. One of that is how about the infringement? Does this mean that the infringement also occurs only if the copyrightable elements of original input are perceptible in the alleged infringing works? And also, what are we actually gaining copyright on or getting registered here? Is it original input? This put us in a, I think it's a guessing game on what rights being infringed. Theoretically, is it a right to reproduce the AI generated work itself? Uh, or is it the right to reproduce the expression of original input, or is it the right to make derivative work from the expression of the original input? This is unclear. I would like to push back a little bit to another case is Surias. Um, just for your information, uh, this image, uh, although non-registerable in US, it turns out it is registerable in India and by India Copyright Office and listed the AI as the author as well, if my information is correct. So I would like to put back into this case, this occurred before the mentioned report being published. So here we have like a photo on left and the right. The left is original, the right is the style. Um, if you're familiar with like the phrase of selection and arrangement of the elements in the picture, you will be able to establish that the left side, the original image is copyrightable. But then when putting it together by AI, the bot say this is unregisterable, which seem like, oh right, it's AI generated work, no human involvement or human creativity, maybe not registerable. But look at this comparison. The original input and the AI generated work. I think the copyright office mentioned in its report after this that if human pictorial authorship is clearly perceptible, then it is registerable. But I don't know. Is this perceptible for you? Okay, just moving on. Just a little bit set of questions that I was raised. Um, moving from what to who, the issue of authorship. So Copyright Act doesn't actually define the author. We rely on case law, like the very old Burgess case, which defines an author basically as the originator, the maker, the person something owns its origin to. And we know that using a tool, even a mechanical one like a camera, doesn't stop you from being an author if your work is original. So a tool is just a tool here. The Copyright Office has been very firm on this matter. Uh, And it's also say that animal cannot be authors. So this also being affirmed by the court. So if you remember the monkey selfie case in Naruto versus Slater, and also the machines cannot be author either, that fought Tyler versus Matter, involving AI system called Dabus. So the rules seems to be no human, no author. But then, um, that's the control test as well. This might offer a way for um that case, plaintiff didn't operate the cameras himself in filming the Titanic wreck, but he controlled very specific artistic choice, lighting, angles, the shots. The court said the final film duplicated his vision. Um, Maybe it's not exactly, but it's look like what he think it should look like. So he had enough control to be considered an author. So the big question is here for AI now is that if you give an AI super detailed prompt specifying the colors, the mood, the composition, every little thing, and the AI spits out exactly what you pictured, does that amount to the same kind of high degree of control we saw in Lindsay? Is that enough to make the user who prompt it be the author? And hang on. I mean, controlling Lindsay was over human operator using basically predictable tools. So if you already have answers in your mind, so maybe uh check out this question. How do you claim the same control over the generative AI as in Lindsay? Because it's often a black box, right? It's generated based on the patterns and probabilities. It's not just follow your instruction directly. That's the absolute core of the conflict. So how do you measure the control over a system that has some level of autonomy and based on some mathematical equations and dimensions? So is it about showing the evidence of control where AI is well trained? For example, if you perturb just only a bit of input and output, then being changed only slightly, or if you put the output back as an input and ask AI to generate a prompt, and then it deliver to you your input or substantially similar inputting prompt. Is that if that happens, can it be the evidence of control and we say that the user has enough control to be the author? So if the AI is truly generating and that implies something more than just being a tool, it feel like the traditional idea of human author controlling a passive tool just doesn't map uh, onto the copyright protection because we have like the model's autonomy on it. So let's shift gears a little bit. We are talking about a study here. It's a very interesting one. Everyone know that we cannot copyright an idea. We can copyright only the expression. So where does an artist's unique style fit in? Style is not copyrightable. It is just an idea, and that is um the key concept. But we do have some courts, and these decisions were criticized heavily. That's saying the style is a part of expression. For example, Steinberg acknowledged that, and also like we have modern muse as well. Um, Courts have been quite clear afterwards, especially in the music case, like Williams versus Gay, that they want grant a monopoly over a whole style or groove. You protect the specific expression, the specific composition of notes, pending, but not the groove, the rhythmic feeling, the swing, or the style of making one image, something like that. But the line of AI models are blurring when they are trained to mimic a specific artist style for me. I will come back to these things later when we talk about training data because it links, in my opinion, with the interpretation of the term demand for original afterwards. But I would like to present a little part of personality theory in copyright protection. This EU case called Painter, involving the portrait photos, and the court noted that the photographer's choice, angle, lightnings, the pose, uh, is similar to Bourgeois selection and arrangement, make it copyrightable. But the court in EU also mentioned that the author can stamp the work with their personal touch. My doubt, even if I'm studying copyright law, in UK and EU as well, but I doubt a little bit like whether or not if we shift the justification of copyright to personality theory, should that personal touch be considered a recognizable style as a protectable part of expression, as a Eckhart in Modern Males and Steinberg mentioned, or is that signature style fundamentally just an unprotectable idea or a way of doing things that anyone or any machine is free to imitate? And that is a huge question for me, and I think a lot of people. All right. Another thing, a big one, training data, liability, and the whole fair use minefield. First thing, maybe the most basic question, does training an AI on copyrighted data even count as copying under the law? So copying requires fixation. The work has to be stored, uh, sufficiently permanent or stable, so it can be perceived or reproduced for more than just like more than transitory duration. So we have here classic case that is Cartoon Network and MAI system. So the rule of thumb is that if the if any information held in memory for less than 1.2 seconds is not considered fixed, but if it's more than minutes, longer than minutes, is considered fixed. So here's the paradox with AI training. So the system might only look at each individual piece of training data very briefly. For example, you input like the image into a training data set, maybe under that 1.2 second threshold, but the result is a permanent change in the model's memory. So the learned pattern, the relationships between pixels of that stuff, should that learned knowledge, that permanent memory be considered the fixed copy itself? Because sometimes it just look like when we are trying to catch the concept of what is cat, what is dog, what is bird, something like that. We do not exactly memorize the whole image. We're just caching those concepts and it's changed our permanent memory. AI do the same as well. And this forces us if to ask if the model internal state is a copy, and it is a really difficult question. So let's say for argument's sake it is copying, then we immediately run into fair use. The four factors and the big one everyone talks about is about transformative use. And also, does the new work merely replace the original? There's a fourth factor, the effect upon the potential market. But or does it add something new with a different purpose or character, something like that is what we call always considered fair use case. And the classic case we see in Google Books, the Van der Heij and HathiTrust, that the critical factor seems to be the substitution argument. Does your use of copyrighted material hurt the market for the original? Does a huge demand for the original? So, this case I would like to raise up a bit is New York Times versus Microsoft and OpenAI is do not focus exactly on the infringement. But here OpenAI trained on Times article. I mean the result. OpenAI trained on Times articles. They didn't just resell the article, but Times give the AI output now substitute their journalism, and the court is digging into whether these use potentially kills demand for the original work, and these seem to be the core inquiry. So it seems like everything is always in line that we examine a very important terms, whether or not it's Q demand for the original. And these were some follow-up question for you. What's the scope of the original then? For example, if an AI perfectly mimics a famous author style and people start using the AI instead of hiring the author, we know that style is not copyrightable, but does that count as killing demand for the original author's work, even if it is just their style being substituted? And perhaps that is a huge debate on this matter. And also, what about the market itself? What if it's changing? What if the publisher like Palm start trying to license their content specifically for the purpose of training AI? Through the creation of new licensing market, swing the fair use analysis against the AI company. If there's a market that you could have paid into, but you scrape the data instead, that looks much less fair. Even if the output is different, it potentially harms that emerging market. But bear with me, because we are going to discuss these afterwards. This slide here is just for you to look at basic infringement of different types. There's nothing really important or new, but in case anyone wants to know, here's direct infringement and indirect infringement, because I'm going to link further to Anderson versus Stability AI. Interesting case. So we have Anderson 1 and Anderson 2. Anderson 1, the court found that the diffusion process involved not copying of images, but instead the application of mathematical equation and algorithm that plaintiff cannot plausibly allege the output image are substantially similar or represent protected aspect of copyrighted training images. The court granted a motion to dismiss the direct infringement claim. So this suggests that the court at this stage focused more on whether or not the final output look like a copy, not on the internal copying mechanism itself. And that's interesting because I would like to show you the plaintiff claim a little bit. Here the plaintiff claims admit that the diffusion process involved not copying of image, blah 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 blah, and finally you mentioned something that it is similar to having a directory on your computer of billion of JPEG image files. So you spot any of the contradiction in the plaintiff own statement, just like interesting. Uh, it's just like interesting things for me. So it's just weird. I think having directory of the store image involves of copying. So but they also admit that that was really for capture of like a concept. So I think it's a little bit weird. On the one hand, they're saying that it's involved copy, but they admit that the process is just capturing the concept, so it is not copy. Anyway, it's not relevant because now we have Anderson 2. Uh, issue of contributory infringement is what I want to raise. The court ruled that the claim would not be dismissed as the plaintiff alleged stable diffusion was designed in a way that inherently facilitates the infringement, and some output can replicate the training images. So the court just says, I would say in simple term that even if the output aren't always copies, but the model itself is allegedly built to facilitate the infringement. That's what the court says. Very nature make it a tool for infringement. So again, then the questions come back that do you think AI's memory works the same way as human memory? If so, could it be argued that we can apply the subconscious copying theory that the defendant knows that the AI has access to the training images and that contribute to the direct infringement by not ensuring that the stable diffusion was designed in a manner that it could not replicate the training image? Maybe if we could answer this question, we could answer something relevant to these matters. And in case anyone wondering what is subconscious copying, so we can see in like Three Boys music called versus Bolton, saying that everything registers somewhere in our memories and no one can tell what may evolve it. Um, so you do not have to actually have access to something, but I mean substantially, but it's just like what you heard of and it registers in our memory, and that also is a way to prove access as well, subconscious copying. I'll quickly touch on the issue of the DMCA and Corporate Management Information or CMI, and the two cases already here. So CMI is the metadata like author, title, corporate notice, that often in the digital files. And Section 1202 of the DMCA protects that. And we saw this weird split in New York courts. It's two cases, Raw Story Media and The Intercept Media, both sue OpenAI, saying it stripped CMI during the training process. It's similar facts, so similar, but turns out the result giving the different standings. So the judge reached the opposite conclusion because in raw story media, the case was dismissed. And the judge basically said the chance of ChatGPT spitting out the articles verbatim uh, was too remote, so no standing to sue. But then in Intercept Media came along, the court, the same defendant, and also the same court claim, but turns out it have a split. So in this case, the plaintiff has the standing. Why? The reason is that because Intercept provided evidence that the expert could actually get ChatGPT to uh, regurgitate the parts of the articles 3 times. So is the key difference just the evidence presented proving the regurgitation is possible, or should the underlying capability of the same AI model have led to the same outcome in both cases? Because it's the same AI model, the same defendant. But the only difference is that in the second case, it is possible to establish that this can reproduce the things in the training data. And but it's just weird because it's the same chat GPT. So now we move to the key fair use case. Starting with the iconic introduction in this case, I really like it. The Just be Bars. Just be Bars, I think. Say a smart man knows when he's right, a wise man knows when he's wrong, and wisdom does not always find me. So I try to embrace it when it does, even if it comes late, as it did here, as a way to uh change his mind in the previous decision. I really love this. It's very cool. Uh, this is in the beginning of the decision, actually. So here, Ross used Westlaw legal head notes, those little summaries of cases. If anyone using Westlaw, is very useful to train an AI search engine. Importantly, the judge mentioned that it was non-generative AI, and the court said, nope, not fair use. Two main reasons. The first reason is that it wasn't transformative. It basically did the same job as Westlaw, just using AI. And the second reason is that it harmed the market. Specifically, the court identified potential market for licensing legal data to train AIs. So the court explicitly pointed out that it was dealing with non-generative AI as well, and this also leaves a huge question. The first one is that does this mean that generative AI models that create new text or images might actually have a stronger fair use because their output is inherently more transformative than a non-generative searching tools? And my feeling when reading this decision is that the cost distinction seem to imply that possibility as well is a massive point. And yes, my gut is right on this matter because you see in the following cases. And another big point to raise, and a really big one for me, is the term derivative market here. The court mentioned that factor 4 does not favor fair use as it also covers derivative market. And this is true. But one potential derivative market is also data to train legal AIs. Isn't derivative market means market for derivative work? So do you think using copyright data to train AI is equivalent to preparing derivative work? And I don't think so. Copyright does not protect use as well. If you can see, copyright protect copying, copyright protect creating derivative work without being authorized is do not protect you from using the copyrighted material. So should the market for derivatives in factor 4 here be extended to a market purely relevant to the purpose of use, or it will be a misuse of copyright? I truly think that this is a mistake in the decision that was made. And it seemed like it was addressed afterwards in these two decisions as well. So we should also mention these bots versus Anthropic and Cadre versus Meta platform. This the recent cases. Key quite similar. So the defendant created a data set to train an AI system. The data set included both pirated books and legally purchased book that first scanned, and afterward, the physical copies was destroyed, and the data set later on was used to train the definite AI. These do not fully represent any of the case, but I think this is the general fact that uh, the following outcome could based on it. So key takeaway from Anthropic seem to be about the source of the training data. Using pirated book is not fair use, but using legally bought library books that were scanned and then destroyed, the court suggested that could be fair use. But Meta view the ultimate purpose of building the dataset is to train the AI. So there's no separate use, only training, and that training is fair use. I'm a little bit skeptic in this matter. So if you remember Reddit, where the platform allows one user to purchase a music file from another user, where the system send the seller's file to the buyer and then destroy the seller's file from the device. And the court did not rule on the distribution right, but mentioned that it is infringement of the right to reproduce. Also further mentioned that the fair use is irrelevant here. So if we twisted the fact a little bit, for me, AI in this case is not uh, anymore the text generator, but perhaps can generate music. Like if you know digital file of music and then permanently delete it after putting it in the dataset, or maybe you buy the actual copy of CD, made it in digital file, and after that destroy the physical CD, will it ended up in the same way? Uh, or will follow the line with digit that okay, is fair use is irrelevant here. We apply different standard for like music. But this pointed that where the data came from do matters. But the training process itself, in both cases, fair. It is transformative, but be careful. I think in the decision it sort of mentioned that substantial harm to market is not properly be shown. So maybe if you can show that using pirated data has substantial harm to market, uh, we may have a complete separation or no fair use for pirated work and fair use for non-pirated work, something like this, or maybe not. Okay, so pulling this together, if you look across all these cases and these legal fights, it feels like the existing framework is really struggling. We see instability around defining the originality, like how much human touch is enough, around the authorship as well, on whether or not it is possible to be the author? Can we have the control over the AI system? And that control is sufficient or not for us to be the author in AI generated work and how to define the control. And around the copying itself, the issue of fixation, the issue of fair use, whether or not this copy there's the act of copying whether or not it was fixed, and if so, whether or not it is fair use. Especially with how these model actually learn and remember information is really problematic. Uh, for these new processes, and maybe the most crucial point for the future comes back to that, but it seems like the trends now that I can get is likely to be that if you train the generative AI, it's likely to be fair use. But if the AI is not generative, it will not be fair use. But that is only for the training process because we still have a split on creating data set, whether or not it is a separate use with training or it's the same use. So this is the final thought for you to consider. A very simple question. It's just like should copyright law evolve and how to evolve in this era? Um, that would be the end of my presentation. And if you have any questions you want to throw in or discuss anything, please feel free to.
There we go.
Great. I'll use my you hear me?
Hi, I can hear you perfectly. Can you still hear me right now?
Yeah, we can hear you.
Okay.
I'll use my moderator role as the first question. I don't know that much about copyright law. I try to avoid it mostly because of that, like the AI usage currently. But like one of the reasons I avoid it too is like I can't really answer the question. And it ties to the debate that like started in Europe with certain AI actions regarding general purpose AI systems and copyright law there, which is like basically also very prevalent in US. Like, what is there like a foundational or a constructional flaw in copyright law that is like that became evident because of AI, basically, with this like human authorship, human design paradigm being like the core of copyright law in basically in both Europe and US. Because like if you look at those debates that you were discussing those cases, we are talking about like for hours and hours and papers and books about like minutia, like the smallest details. Like we are basically discussing if you affect more than X number of pixels in a photo, you are an author, and if you don't, you are not. Which is that's not like I don't know copyright law that well, but like for a lawyer, it feels like something went wrong. We have to discuss those things. We don't really have rules. We're just trying to make a standard more than like legal rules. So that's my like philosophical question.
Perhaps. Let me share this a little bit. Um, I think right now we do not really have the uh I think a clear milestone on what it will look like or what it will be shaped, right? Because all the case that was mentioned, especially when it's involved AI, they are all not decisive. I think UK just released the new case decision on get the image versus stability. Uh, that is the first and actual case on the issue of AI and training and infringement and the output and so on. And it seem but it's just look from overall, it's just look like UK uh try to grant exception over uh any copyright matters that uh relevant to AI training and AI generated work, something like that. In EU, I didn't see it, or perhaps not yet being updated. Mm, but I think this is very interesting because we also have like a fun debate in EU, right? Not really a debate, but many lawyers or scholars or I don't know, whatever will suggest like opt-in or opt-out regime for copyright, saying that okay, you can use all the data for training AI, but you should grant it right to opt out. But the question that I always ask, and I'm a hardline in this matter, is like if training AI is exempted from infringement, why do you need to opt in? And if it was oh no, sorry. Yeah, and if it is really you know, if it is not an infringement, if you can really do it, and why you need to give an option to opt out for it, something like that. I don't know if this kind of can answer or support whatever you just mentioned, or is there anything further that I should address specifically?
Like I think you pretty clearly stated like at the beginning that you don't want to try to like create a new framework for it, and I get it. Like those cases are interesting on their own. So yeah, so I basically asked about the bigger the bigger picture while you explicitly stated that you don't want to do it. But thanks for the answer. Anyway, and do we have any other comments here or questions? Or Karen, do you see people on the internet? And because there are some people in the call. they're like asking questions or raising hands, because we usually skip those. Forget about those people.
Hold on a sec. I was in it.
I'll take that as a no right now, right?
Well,
I can go. So may I?
Yeah.
So I don't know.
sorry.
I don't know much about the copyright laws. So essentially, this question is coming from somebody that has like kind of zero knowledge on this topic. But essentially, I'm trying to understand your argument. What you're saying is it's going to be difficult to apply to AI what we have already applied to other cases for copyright laws. So what you are suggesting is like we then either don't apply or we need to adapt the rules, or more what you are saying is we can stay with the same established framework, and then we need to redefine some things and then apply the 3 criteria that we have been applying so far, and that's it. So it was difficult for me to like take the message. Where are you going essentially?
I see. First thing first, I must apologize because there's a lot of questions coming up in like the presentation, right? And it may mess up a little bit, especially if you do not have like a copyright law knowledge. But what I'm trying to do so far is saying that I think the current framework, the current law, everything is sufficient for dealing with this matter. But we just have a lot of questions that I stated out that we need to be able to answer those things. And if we can answer those things and decisively, then I think traditional copyright law, traditional framework, all the factors, everything, and key cases, something like that, will be sufficient to dealing with you know uh matter of originality in AI generated work, matter of authorship in AI generated work, and also infringement as well. That would be my answer. Does that answer your question?
Yeah, maybe triggers a follow-up. So essentially what you are saying is like don't modify the existing laws. So it's like just wait for the courts to establish precedents where they start interpreting those things and establishing what do we mean by originality in the context of AI, for example. No, that's what you are suggesting.
For now, I would say yes. That is my idea that I want
Okay.
to convey.
Good.
Just a
Well,
little bit
I
more
had the-
clearly. Sorry. What I mean is really not waiting for the court, but I think it's just like waiting for someone to answer those questions decisively. And even if we do not have the court ruling on certain matters, maybe we have like another kind of AI generated work that never be litigated. But if those answers could be answered clearly, then we will likely to know the result, the outcome, something like that. But yep, it's pretty accurate.
I had the same thought that Gustavo said. I was trying to figure out where this was going. And I kept looking for, all right, there's some law that were in place already. And you made it, I think that's what he needs to add to the presentation, that the summary would be as we're waiting for the courts or whatever to give us some guidance here. And he gave some good examples, but it didn't quite finish. And you asked the right question.
Yeah, so it's like just maybe a follow-up on this. So one possibility is that you wait for the rulings and then the rulings start establishing like a line in the sand, okay? And then the other possibility is like people start thinking about this, so they start providing some ideas, because I bet that some of the courts are probably quite lost on these things. It's like I can imagine it's like you have to rule on this. Like, okay, for a typical pre-AI copyright case, I more or less have an idea how to rule, but then I am kind of lost how to apply those things. So what you are suggesting is like maybe there is a room for, technical people and maybe lawyers to start, helping the courts coming up with some criterias, and then the courts will be essentially absorbing or refusing to absorb some of those criterias. That's where you are kind of heading.
Exactly. That's what I try to convey. I mean, in my original work, I do have like a pre-AI era cases as well, but I just didn't put it down because it's what is very basic in like a copyright class, and it will make the presentation very long and will do not have sufficient time for discussion. My apologies for that.
Have to one comment and one question. The comment is that that's not how all legal traditions work. You're answering the question that Gustavo asked for commons law. It is a question that is based entirely on jurisprudence. That's not how civil law works in the rest of the world. So that combination of commons law and civil law has to be taken into account when thinking about legal traditions. That is my comment. My question is, if maybe some of your work specifically addresses academic work. I know we're facing this in journals, for example. We're struggling with defining the limits of what constitutes an original article now that most of them are using AI.
Sorry, can you repeat the part of the final questions again?
Yes,
I couldn't.
Sure. The question is that if you know of any examples for the academic world, in particular for scholarship and publications in journals. I think this is a big issue when you think about knowledge production.
Like for some research work done by scholar about this matter, right?
But about knowledge production within institutionalized forms of scholarship, so academic journals, as an example. If maybe you have any
like any backup for it. If I hashed the question correctly, let me catch. I have like some paper that I read through for like this method. It was written by Professor Peter Yu in Texas A&M. And he did mention about like the way of, the development of copyright law when come to AI generated era as well. He do also presented some idea of the control in establishing the author in this case as well. Is that answer your questions?
Yes, thank you. I'll look for it. Thank you.
I see.
Maybe your first question was also interesting, the civil versus
Yeah.
common law thing.
Yes, so the way in which you are referring to creating present doesn't apply
Yeah.
to other
Yeah,
legal
let me
traditions.
find like the actual paper names because I cannot remember the title of the paper, but it is in like my device, and I will send to uh the workshop, and maybe the workshop can distribute to everyone. All right.
Sure, thank you. Super interesting.
Thank you.
I've been dealing with it, day to day. So
Oh, I see.
How do you decide?
this is not original. I'll be there. Yeah. A bit crazy.
Do you have any more questions? Don't see anything online too. Okay, so thank you, everybody. Yeah.
Right. Thank you so